So, welcome everyone. My name is Tom Wainwright. I'm a barrister specialising in criminal law at Garden Court Chambers in London. And this is our webinar on neurodivergence in the criminal justice system. It's part of the Garden Court series of webinars, which we've been running since September of last year, looking at neurodivergence in the justice system generally, so not just limited to criminal law and the criminal procedure, but looking at different aspects of the justice system: family, immigration, civil, housing, education, all sorts of different areas. And part of the reason for that is to try and bring together practitioners in different areas, academics who specialise in different areas of law, other participants in the justice system, to address the particular barriers specifically that neurodivergent individuals who come into contact with those different areas of law face. Identifying areas of best practice and good practice, and hoping to build bridges between the different areas of law, between the different areas of the legal profession and academia and other participants, so that we can potentially think of ways to improve the system. And it's become apparent in the course of those webinars that there are so many different topics and areas that we need to address. I think really tonight's webinar is a good example that I could quite happily listen to all of our speakers for an hour each, but we have to get them all in within an hour, so I'm afraid we're limiting people to about 10 minutes. But what we hope is that those who are listening, those who participated in previous webinars, and the speakers themselves may find from tonight's webinar and the others in the series that things spin off from it, that connections are made, and further projects might develop in this area. So we are specifically focusing on the criminal justice system tonight, from the police station through to trial and sentence, and the impact of custodial sentences. And we have a range of experts joining us, looking at those different areas so far as they impact upon neurodivergent individuals. And I'm going to briefly introduce them at this stage. We have Hope Kent from the University of Exeter, Tom Dodsworth from the Mayor's Office for Policing and Crime, Kathryn Jellings from 3SC, Dr. Thomas Smith from the University of the West of England, Andrew Sperling and Emma McClure from SL5 Legal, and myself. And we'll be speaking in that order on different topics each. And I'm going to, without further ado, other than to say that we will hopefully have time for questions and answers at the end. If anyone has any questions at any point, please put them in the Q&A box, and we'll try to deal with them as many as possible. We're unlikely to be able to deal with them all. But without any further ado, we will start, and I'm going to introduce Hope Kent, who's a postdoctoral research associate at the University of Exeter, studying neurodisability, focusing on brain injury across a range of contexts, including education and the criminal justice system. And in the current projects, she's using Ministry of Justice and Department of Education data to understand pathways into the justice system through education and social care outcomes. And she's particularly interested in social models of disability and how we can make systems accessible and appropriate, particularly for children with neurodisability. So I'm delighted to hand over now to Hope.
Lovely, thanks so much, Tom. I'll just work out sharing my screen very quickly, and hopefully you can see that. I've sort of lost vision of you, so if anything goes wrong, just shout and interrupt me at some point. But it's so great to be here, and absolutely fantastic to have so many people online to talk to about this as well. So thank you to Garden Court Chambers for putting this together, and to Tom for your organisation too. And yeah, as Tom's already hinted, I've got 10 minutes to talk about this topic that I could talk about for a really, really long time. So I will try to get through everything and not take up too much time. But just to say up front, I'm going to talk quite a lot about children in police custody suites, meaning anybody who's under 18, because that was the focus of this project that we just finished working on. But everything that I'm saying is really relevant to vulnerable adults as well. I have got some data from vulnerable adults, so I'll refer to that throughout as well. But yeah, just as a heads up front. I just wanted to start off really by flashing up this general comment, number 24, on the Convention of the Rights of the Child, which sort of deals with children with developmental delays or neurodevelopmental disorders or disabilities, which sort of encapsulates everything that we would cover under neurodivergence as well. And it says that they should not be in the child justice system at all, even if they've reached the minimum age of criminal responsibility. And if they're not automatically excluded, these children should be individually assessed to make sure that they can access their rights on the same basis, a sort of equal basis as children who would be described as neurotypical. And I think that's really important to just hold in mind. I'll refer back to it later on in this presentation, but also hold in mind for the discussions that we have going forwards as well. And I just wanted to acknowledge as well that I'm using the term neurodisability, which is a conscious decision in order to kind of specifically evoke these legal protections from this general comment, and also from the Committee on the Rights of People with Disability as well. But just to say that I am referring to the same collection of conditions that would come under the umbrella of neurodivergence, and just kind of address that difference in terminology there and say that that is a conscious choice that I'm making. So I'm going to talk very, very briefly about the results from this project, which was funded by the Nuffield Foundation. It was led by Dr. Vicky Kemp at the University of Nottingham, who's a fantastic and very passionate researcher. And this final report is available on the Nuffield Foundation website. There's a link to that at the bottom there. And then we also did a further analysis. So this report focused on child suspects, but we did a further analysis on adults but suspects as well. And that's available on the Nottingham Research Group website. So when the slides get circulated, if you're interested, please do look up those reports. This final report was 120 pages long, so I really am skimming the surface of what we found. We explored absolutely loads in terms of intersectionality, outcomes like strip searches, legal advice requests, vulnerability. So if you're interested, there is lots and lots more information in those reports available. But ultimately, the project was a mixed methods project. So we worked with about 51,000 electronic custody records, of which about 3% related to children. And then this was accompanied by some interviews and case studies with 32 children to try and get a really holistic picture of what's happening on a national level, and then also some rich qualitative data about what's happening to children who end up in police custody suites. We went out to all 43 territorial police forces to ask for their data. We worked on data sharing agreements with about 29 forces, which was really difficult. We ended up getting data in from about 12 forces, and then we were able to actually conduct analysis on the data from 8 forces. And then these interviews happened across three forces. So that's sort of an overview of the data that we're working with. The electronic custody record data, under PACE, the Codes of Practice, a custody record has to be open for each person who is detained in custody. The record must include information like demographics, requests for legal advice, offence types, vulnerability, and the time that people spend in custody. So it's actually a really valuable resource for research to be able to understand what's happening to people in custody and what the profile of people coming into custody is. So some key findings from the electronic data. The first thing to note is that when somebody's brought into custody from a response team, from a police team, the supervising custody sergeant has the option to refuse to authorise detention. So as they come through the door, the custody sergeant can decide to authorise or not authorise that detention. They might refuse detention if it seems disproportionate, if it could be dealt with in a voluntary interview, if the person perhaps has health conditions that means they shouldn't really be kept in a cell in custody. And one of our key findings was that custody sergeants were refusing detention in less than 1% of cases. So that detention was pretty much automatic there. So thinking back to that general comment on the rights of the child, what we're seeing is people being brought into custody, and that decision not really being disputed in very many cases. And I think that's important. And then despite that, so detention was pretty much automatic, but what we found was that half of adults, 52% of vulnerable adults and 56% of children, then ended up resulting in no further action as an outcome from that first custody visit. So that's implying to me, certainly, that actually there's a lot of people in custody who don't need to be there, particularly a lot of children, a lot of vulnerable adults who do not need to be in police custody, but that detention is being authorised almost automatically. So that was one of the first sort of really obvious findings. And then when we looked at the amount of time that people were spending in custody, we found that adults were spending about 14 hours. Vulnerable adults were spending longer than that, so about 17 hours, 3 hours longer in custody on average, and children were spending 11 hours and 36 minutes, which is still a really, really long time, and there was more than half of children being held overnight in custody as well. And so we weren't able to interview any vulnerable adults, but when we interviewed children, we know that their time in custody was very distressing. They often saw it as part of their punishment, and unfortunately some of the custody sergeants saw it that way as well, that it was kind of like a bit of a shock treatment, that it might deter them from coming into custody in future, which is definitely not the way that things should be. And the way this works in terms of timing, there's a 24-hour pace clock, which means that somebody has to be dealt with within 24 hours unless it's extenuating circumstances, and there are sort of reviews throughout that 24 hours to make sure that things are moving on. And one of the things that's arisen from this work is that some of the forces are piloting a 12-hour pace clock for children in custody, which means that they would have to have extenuating circumstances to hold a child for longer than 12 hours, which is a really good thing. But I think something like that could be explored for vulnerable adults as well. There's no reason to limit that to just children. And we really explored this difference in the time being spent in custody with vulnerable adults with our steering group. And the reasons for it are really, really complex. So it could be related to higher rates of legal advice being requested. So about 60% of adults, 80% of vulnerable adults, 80% of children were requesting legal advice. And that might be because they've got an appropriate adult who's advocating for a lawyer, and there's time associated with setting all of that up. But actually, our representatives from appropriate adult societies and from law provision also said that they're ready to go. They're not waiting on the appropriate adults or the lawyers to arrive for interview. They suggested that perhaps the police are going out to collect more information about the case to go to interview, as they know there's going to be a high likelihood of having a lawyer there and the appropriate adult there as well. So that was a possible explanation, but we really don't know too much about getting to the bottom of it. But I thought that was pretty striking, keeping vulnerable adults for 3 hours longer. Just to flag as well, the quality of the data was really, really poor and really difficult to work with, very inconsistent in terms of what was collected. So this is a bit of an overwhelming table, but what I want to draw your attention to is, number one, the discrepancy in which forces could provide which information electronically. Lots of this stuff would have to be a manual pull if you wanted the information, which isn't feasible on a large scale. The person vulnerability warnings as well, we asked them to give us information about somebody's vulnerability factors that they might have, any flags that they had on record for that person. And these were really varied. So most consistently, forces were able to tell us things about mental health, self-harm, suicide. There was essentially no forces that were able to tell us any substantial information about neurodisability. There was a flag for disability, but there wasn't really much indication as to whether that was physical or whether that could be including a neurodisability. And the other concerning thing was that lots of these vulnerability flags about mental health, etc., were mixed in with flags like being carrying firearms or being an escaper or concealing items. These sort of like warning flags were mixed in with the vulnerability flags, and I'm not sure that that gives the right message on how vulnerable people should be dealt with in custody. There were definitely pockets of good practice. So some of the forces were trialing out different screening for neurodisability, but overall, there's really no evidence in the electronic custody record data of what is happening to people with neurodisability who turn up in police custody. But in our case studies, we found that 22 out of our 32 case studies for children had some kind of mental or physical health issue. 11 reported having ADHD, 3 reported being autistic, 2 had mental health problems, another 2 had anxiety, and also while some of our children had received a diagnosis, others were waiting for a diagnosis or waiting for an appointment to be screened. So what you see there is that there's a massively high level of need, which we know is consistent across the justice system, and that's not being reflected in electronic data, which means that it's very difficult for forces to be accountable on a national level to the Home Office in terms of what's happening to those children. Additionally, the time in custody, like I said, was just really distressing. It was really boring for children. They found it really punitive. And of our 32 participants, 18 said they didn't understand their legal rights. Another 4 on top of that initially said that they did know their rights, but when they were asked, they weren't able to describe them. And then there's 2 quotes there as well from children in police custody who sort of compared it to the youth custody estate and said they would rather be in a YOI, in a young offenders institute, than in police custody because it's so awful. They weren't eating anything. This second quote from a child who didn't eat anything for 19 hours because the food was bad, and we know that hunger pangs can impact decision making in custody. And there's really so many quotes in this project that I could pull out that demonstrate what an inaccessible, harsh and punitive environment this is for children. So we made a series of recommendations coming out of the report. I think refusing detention in more instances would be much more in line with that UN general comment of not bringing children into custody at all, not bringing people with disability into custody. Better data collection that would capture and report that data publicly. That would just help to improve transparency and fairness regarding police powers and people's legal rights. And then mandatory vulnerability flags that relate to neurodisability, that have oversight from the Home Office so we can see if people are being unfairly treated, if they're being held for disproportionate amounts of time as a result of some sort of systemic failing that's happening in terms of dealing with them quickly. And then my final argument that I've been making quite a lot recently in relation to child justice systems is that making them more accessible would benefit all children. There's not a single child coming into custody that would not benefit from having their rights presented to them in a more accessible way. So where we run into challenges in police custody suites with police saying they haven't got time to screen, it's expensive to screen, they don't know what to do with the information when they have screened, it makes sense to make custody suites much more accessible for everybody and make those adaptations for everybody and use it as a last resort system for everybody, particularly with the massive prevalence of neurodisability that's in there at the moment. So I think that is my 10 minutes. So I'll leave my email address there if anyone wants to be in contact. We'll keep an eye on the Q&A box as well if anybody's got questions or anything else that I can answer. And yeah, thank you so much for listening and really looking forward to the other presentation.
Fantastic. Thank you very much, Hope. I'm going to go straight over to Tom Dodsworth and Kathryn Jellings and very brief introductions, because I think certainly Tom may have to leave in about 10-15 minutes, and we're anxious to hear what he has to say. So Tom is the Policy and Commissioning Manager at the Mayor's Office for Policing and Crime. His work includes crime and violence reduction work across the adult system, which includes policy development, new services and innovative pilots. Kathryn Jellings is the director of 3SC, a social business which seeks to provide opportunities to the third sector, micro SME and small business in government contracting. And has been involved in delivering a number of programmes for neurodivergent people. There is more that I could say about the wonderful work that both of them are doing, but perhaps I will hand over to them and let them tell you about it themselves. So Tom and Kathryn.
Thanks, Tom. So thanks for sparing me this time today. I'm just going to give you a brief introduction about some commissioning work that we've been doing in MOPAC, and then I'll hand you over to Kathryn, who can tell you a bit more with a lot more expertise around neurodivergence and the work that's being done, not just in London, but around the country. So together with London Probation, MOPAC have done some co-commissioning in the last kind of 12 to 18 months, recognising, as Hope was saying, the kind of prevalence of neurodiversity within the CJS. And in London, we're doing this as part of integrated offender management, which is a kind of partnership that manages the most persistent violent offenders in London. They're all adults. There's about 2,000 of them at any one time, and they typically commit a kind of repeat pattern of acquisitive and violent offences, quite predictably throughout their adult lives. So they have entrenched needs. And we looked at the evidence base around the need and some of the things like the findings of the HMIP review on neurodiversity within the criminal justice system, which highlighted that neurodiversity was likely to be a really under-recognised need that we needed to think about. So, as I said, we've commissioned a service which is launching this month. Very exciting. That's what Kathryn's kind of right in the delivery phase right now, starting that off. And in brief terms, the service has 3 elements. So we are looking to screen as many of those 2,000 persistent violent offenders as we can using a verified screening tool in the next kind of 18 months to really build up an evidence base of what the neurodiversity need within that cohort is and to get a much better understanding of that. We're also going to be offering one-to-one support and assessments and coaching, which Kathryn can talk about, for individuals in that cohort to really help them understand their own needs and for them to kind of get adaptations in the support that they get from the partners involved in integrated offender management. And we're also going to be running a wide-ranging training program of kind of skills and knowledge for probation practitioners, for police officers, for staff working in local authority funded services and partners right across London who are delivering interventions and services to these people, so they have got the necessary knowledge they need to work with them. We're working with colleagues in MOPAC's Evidence and Insight team, so we will be using this data in a number of published evaluation reports. So this is not just a programme about intervening and hopefully reducing repeat reoffending, but it's also about adding to that evidence base and kind of producing some data around what that need looks like within this cohort. I think there's just one more thing I'll say, and then I'll hand over to Kathryn, who'll say a lot more, I think, about the best approaches to neurodiversity. I'm bigging you up, Kathryn. Yeah, I think when we did a lot of work in preparing our commissioning around talking to people with lived experience. We had a number of task and finish groups with people from across prisons, health, police, all sorts of different people. And the kind of one major takeaway that I took from that is that when you're looking at services for these people, there's such a diversity within each condition, let alone all the different conditions, that our service is focused on taking a person-centered approach to each individual and listening to them and finding out what would be helpful to them in quite simple, practical terms. These people are entrenched in the system. We're not going to be able to take them out of it in a simple way, but hopefully there's a lot more we can do to help them get the right support they need and navigate their way through. But I'll stop there. Kathryn, hand over to you.
Hi, everyone. So I'm Kathryn Jellings. I'm Director of 3SE. So as other Tom said, 3SE is a social business. And for the last 5 or 6 years, neurodiversity has really become our specialism, I guess. We're now at a point where all of our programs have some level of neurodiverse interaction with them, which is a very exciting place to be. So our journey within the justice system started with a really small pilot program for the Swansea probation service in South Wales, delivering a 1-year program to people who were autistic and on probation. And as the phrase goes, from those little acorns some mighty oaks started to grow, and we now deliver a full neurodiversity service across the whole of the West Midlands, supporting people on probation. We also deliver a very similar program across Wales. And we also deliver an autism-specific programme for Thames Valley Probation Service. So, as Tom mentioned, the IOM London project is very new to our portfolio. I'm actually in a probation office right now, having finished up delivering some training for the team here today, which has been lovely. And actually, the IOM program itself is a really exciting program, I think, and it is very different from a lot of the other services that we have. So it starts off with this really big, intensive screening program. So in my experience, we've never seen a screening program like this, certainly not as expansive. So we're aiming to screen the entire IOM cohort in London. So that's 1,500 people over an 18-month period. Crucially, I think we are not seeking a diagnosis, and actually none of the 3SC programs actually request a diagnosis. And I think that's a really important thing. We're looking for prevalence of neurodiversity, and we're looking for traits, because we know the route to diagnosis can be really long and really painful for a lot of people. And actually, if it's going to take you 5 or 6 years to get a diagnosis on the NHS, then actually those little molehills that you started off with over that time have grown bigger and bigger and are suddenly mountains. So we'd rather not put people through that anguish and stress, and we'd rather pick them up at the earliest possible stage, which is what the IOM London programme is seeking to do. So it's really commendable on that basis, and is certainly a model that other services should seriously look to. Then the other crucial thing, and I think what makes the 3SE model quite unique, is we follow professional coaching methodologies. So the type of coaching, I don't know, that an international CEO would receive is essentially the same bare model that we would use to support people on probation. So when you've got a lot of chaotic thoughts that are all spinning around your brain, it can often be difficult to focus on one thing. So what we do with the coaching model is actually kind of almost teach them how to coach themselves as well. So it involves them kind of putting into order some thoughts and using some logical steps to start to solve their problems. We particularly use the Oscar methodology because that has a piece in it that is around choices and consequences. And for someone who maybe hasn't made the best choices in the past, it's actually a very useful tool to make better decisions in the future. So we're very convinced that it has a really positive impact of the ultimate aim of reducing reoffending. And, you know, it's for some people, just realizing that they have a choice can be really life-changing. The opportunity to speak to someone around their neurodiversity and almost be able to disentangle themselves from their neurodiversity. So, you know, we've all got a prevalence of beating ourselves up, but actually people who are neurodiverse can often suffer low self-esteem and anxiety because they're almost conditioned by society to beat themselves up, and you know they've probably had bad experiences with school and prisons and you know lots of different institutions over the years as well. So a program which seeks to undo some of that and say, well, actually the reason that you're always late might be because you have ADHD is very, very liberating for a person. You know, it's almost like some of those things that they have which have held them back, they can let go of because that's their neurodiverse self. So really just kind of focusing on a strengths-based model and building people up as much as we can is very, very useful. And the screening piece itself is using the Do It Profiler, which was the author of that is the amazing Professor Amanda Kirby. And that's a model and a tool for screening that is highly beneficial and actually jumpstarts that person's journey with some initial aims and objectives. So, you know, coaching is beneficial for everyone, but actually when you implement it for a person who has neurodiversity and has many, many years of struggle, kind of putting some of those pieces of the jigsaw into the right holes can make a massive difference for them. I hope that's okay. Is that enough? I can keep going.
Unfortunately, we've got to move on, but thank you so much, Tom and Kathryn. That was wonderful and very exciting to hear about. So we're going to go from one Tom to another, but I'm going to refer to this one as Dr. Smith, perhaps to make things easier. So Dr. Tom Smith is Associate Professor of Law at the University of the West of England. His research focuses on suspect and defendant rights, pre-trial detention and neurodivergence in the criminal justice system. We're particularly pleased to have Dr. Smith join us as he is the founder and joint coordinator of the Neurodivergence in Criminal Justice Network, which is a group of academics, practitioners and community members, which I recommend that everyone who is watching this webinar join immediately upon it finishing, so that we can build that network. And Dr. Smith's also published on his area of specialism, including an edited edition published last year on autism and criminal justice. So I'm very happy to have Dr. Smith join us, and I'm going to hand over to him now.
Thank you so much, Tom. That's a very kind and generous introduction. Let me just share my screen a second, as I've got a few slides. I'll assume yes. Yeah,
yes,
sounds like it.
Yes.
Perfect. Great. Thanks so much to the to Garden Court for inviting me to speak tonight. Again, conscious of time, and like everybody here, I'm sure I could say many things about all the points I'd like to kind of cover tonight, but I'll try and keep it concise. Not my strongest point, but I'll give it a go. So I'm going to be focusing on criminal courts and the potential issues and challenges that arise in relation to neurodivergence in that context. I often speak about this in terms of defendants, in that my background is primarily research related to suspect and defendants' rights, but I think pretty much everything that can be said also applies to victims and witnesses and other participants in court processes. So I hope that will be kind of borne in mind as I talk. Okay. I don't think I need to really dwell on this, because I suspect by this point most people are very well versed in what neurodivergence means. But just briefly, I think it's always worth highlighting the difference between neurodiversity as a sort of equality, humanity. We are all neurodevelopmentally diverse, but those who are neurodivergent have a different form of developmental profile. And, you know, from a medical perspective, we tend to talk about things like autism, ADHD, dyslexia, and so on and so on. There are many conditions now kind of recognized within this umbrella. But in terms of relevant kind of differences, again, it's very difficult to generalize, but things like social communication, language, memory, sensory challenges, motor skills, mood regulation are things that can be different and challenging in certain contexts for neurodivergent individuals. So in the context of the criminal justice system, as you know, you'll be very aware at this point, there's been a lot of work being done in recent years, increasingly anyway, to kind of identify things like prevalence, and the general consensus seems to be that neurodivergence is probably moderately to highly prevalent in the criminal justice system, whether that's as victims of crime or suspects, defendants, or offenders. Now, in this context of criminal justice, being neurodivergent is not inherently a barrier, but the way that the criminal justice system operates and works, and what it focuses on, can make being neurodivergent a barrier to access to justice. So criminal courts, very obviously, are highly verbal. They're dependent on oral interaction between people. They involve sometimes arcane, outdated, and strange, but generally unfamiliar processes and languages for anybody who hasn't been to a court before. They can be chaotic, or they can be highly pressured. They can be slow-paced. They can have significant sensory challenges for individuals in terms of the environments in which they take place. And all of these kind of potential challenges for neurodivergent individuals in courts can affect them in various ways, whether that's being a barrier to understanding what's happening, being able to engage with the different professionals they're encountering. And ultimately, this, you know, has potential impact on not just their experience, but the quality of the evidence gathered in criminal courts and the outcomes we see in worst case scenarios, wrongful convictions or miscarriages of justice. So if we don't kind of recognize and respond to this, then you know, ultimately the system is failing this group of individuals, and the evidence seems to point to this being something that is a problem. it's certainly at a systemic level anyway. So, for example, the quote I've put on the slide is from the Criminal Justice Inspectorate's report from 21, talking about serious gaps, failings, and missed opportunities at all stages, as it put it. Another concern, of course, is that the system is the people who run it, and that, you know, the understanding and awareness of neurodivergence across the system, including in courts, including lawyers, judges, legal advisors, ushers, you know, all of those people, is, you know, there's no evidence to suggest it's good. In fact, as that report suggested, there's widespread ignorance. And under identification, screening has already been mentioned just a few moments ago by Kathryn and by Hope earlier, and our kind of failure to understand actually how many neurodivergent individuals are in the system is a major barrier to really addressing any of this. So in terms of courts, I've just tried to very briefly summarize here some kind of common potential barriers for neurodivergent defendants or witnesses who come into contact with courts. One kind of primary one based on, you know, communications, the kinds of language used in courts, which can be very difficult to access for anybody, but may be almost impenetrable for a neurodivergent individual, for example, somebody who has a developmental language disorder. Questioning styles, for example, if so a witness is being questioned or a defendant is being cross-examined, questioning styles can be very difficult or a major source of problem in kind of engaging that person effectively for the purposes of gathering evidence. So if very open style of questioning is used by an advocate, that may be a major barrier, for example, for an autistic defendant, or the kinds of language used may be interpreted in a very specific way. Memory and cognitive processing tend to sort of be associated with various types of neurodivergence, and, you know, often there may be a need for more time to be allowed for people to process information in the context of a court. But live courts are, you know, pressured. Time is always ticking in court. I think, you know, everybody and aware of the court backlog now, and that pressure in the background for quicker well with this particular issue. The way neurodivergent individuals present, as it were, so externally show their neurodivergence, can be misinterpreted, whether that's their language, their demeanor, their behavior. It may be misunderstood and held against them in certain circumstances if people do not understand why they are communicating or behaving in a particular way, particularly if individuals are kind of held up to stereotypes of certain neurodivergent conditions. And particularly as well, if individuals do not fit this sort of idea of a vulnerable person in court, and if that person doesn't look and seem vulnerable, then they're simply dismissed as not being vulnerable and not given support. I've also mentioned their sensory overwhelm and failure to offer support, such as special measures, which are supposed to be available, certainly for victims or witnesses, and really should be available for defendants, though that's a different issue that I won't get into right now. So if that's not addressed, we're talking about breakdown in communication, neurodivergent individuals being judged in potentially incriminating ways, or in ways that suggest they don't have remorse, or that aggravate the way they are judged, and just a general kind of barrier to neurodivergent individuals being able to understand and be understood in that context. And of course, all of this can lead to a personal form of trauma and harm to them, simply by being brought into that process. And ultimately, the criminal court is there to gather evidence in a case and wants to achieve best evidence, ABE, as the term goes, and that will have a negative impact on that. A couple of examples here, just briefly, a couple from research, one from Slavny Cross and others, who examined, I think it was around 93 cases of autistic defendants, And essentially in half of these cases, or more than half, I think it was, juries were not informed they were autistic or why this might be relevant to their decision making. And they found a significant number of prosecutors saying things that suggested they just did not get what autism was. A case example there as well, a witness with ADHD, essentially subjected to a completely inappropriate experience for a witness with that condition, and which led to them refusing to return to court. And that was the end of their evidence. And of course, that could be the end of that case and any prosecution success. And then an example relating to developmental language disorder, juries, mock juries in this case, considering defendants less likable, more dishonest, more able if they did not know about this condition. So that kind of idea of knowing about who the person is who's before you in a court for both professionals and juries is really, really important. And then finally, because I'm sure I'm about to run out of time, what could be done about this? Well, identification, I think, it seems to be one of the kind of major important first steps. We need to know who is neurodivergent in that system before they can be assisted. And screening at the moment is so fragmented. There's good practice, there's no practice, but at the moment, largely we rely on individuals picking things up. And until we can do that, we can't make the kind of adaptations that I've suggested on the slides, such as adapting communication, making sure people are informed that someone is neurodivergent, being more generous with time, having some kind of coordination within a court, such as a ground rules hearing, to get the best approach to a hearing, and being more willing culturally, I think, to extend things like special measures, sensory adjustments, personal items to support individuals, and also recognizing as well that courts are not clinicians. They need help and support in managing these kind of things, so they should be accessing expert evidence, intermediaries, other individuals such as family members who know individuals best. So I think I'm probably out of time, so I'm going to stop there and finally just say, as a brief call, I'm involved in a piece of research at the moment asking barristers and solicitors about their experiences of representing autistic clients, looking to interview individuals. So if there are any lawyers in the room, please get in touch. We'd love to hear about your experiences. Thank you very much.
Fantastic. Thank you very much. Just on that last topic, I think, as I said at the start, one of the hopes of this series is to build and make connections. So if anyone does want to get in touch, I know some of the panelists have already put their details in the chat in relation to specific projects. If anyone has any ideas for other projects, further webinars or anything that we could do, please do get in contact, and Garden Court's happy to facilitate that taking place. So I'm going to now introduce, I'm very happy to say, Andrew Sperling and Emma McClure from SL5 Legal. Andrew's a solicitor advocate, director of SL5 Legal, specialising in judicial review, parole board, advocacy and human rights. He's been previously commissioned to work for the parole board, producing easy read guides to parole for people with learning and communication disabilities. He's provided training for the parole board, the National Autistic Society, the Bar Council and others, and he's a facilitator for the Law Society's Advocacy and the Vulnerable programme. Emma McClure is an experienced representative for clients at parole board hearings, category A reviews and judicial review, with particular interest in assisting those with mental health needs and those who've been detained under the Mental Health Act during their sentence. Emma is autistic herself, and that gives her a unique perspective and understanding when assisting neurodiverse clients. And so we're very excited to hear from both of them this evening. So Andrew and Emma, over to you.
Thank you very much, Tom. Good evening, everybody. Just the first warning from me, there are no slides, so you're going to have my face before you for the entirety of my my section here. The other thing is I feel like I should be called Tom, because almost everybody here is called Tom. I'm not called Tom. I'm Andrew. My family are always telling me that I should just get to the point. So speaking for 5 minutes on an area I could talk about for hours is going to be a bit of a challenge for me, but I'm going to do my best. And Emma can beat me if I talk for too long. I've been acting for prisoners for about a quarter of a century. I set up my own firm, SL5 Legal, around 8 years ago. My colleague Emma, who I'm very happy to share this talk with, is one of our team. I don't know how much those present will know about the parole board. I don't think I've got enough time to do a kind of comprehensive overview of how the parole board works. I think just to start with, I'm just going to say that that we are the parole board and people who work in the parole process are at the back end of the criminal justice system. So lots of what you've heard about people at different stages of the process is obviously relevant, but we as advocates will act for people who have been through the system already and are trying to get out of it. So our responsibility as advocates is to try and assist our clients to navigate the system and to ultimately, in most cases, to try to get out of prison. So Tom mentioned that a few years ago I was commissioned to work on a project at the parole board. Once I got my feet under the table there, I tried to make a difference in some other areas, and one of those was the way in which the parole board managed cases involving neurodivergent prisoners. I have been instructed in a lot of cases in which clients of mine had really struggled because the processes in lots of ways were inadequate or inappropriate for them, given their particular communication style or needs. Some people found the whole process completely baffling and intimidating. Some inadvertently made things much worse for themselves just by being themselves in an environment which didn't really recognise neurodiversity at all. So while I was at the parole board, I tried to advocate for some changes. It's a big organisation with lots of different priorities, so it was quite difficult for me to get very far in the short time that I was there, and I had to really settle for getting an easy read guide to parole, which has since been included in every parole dossier that I've seen since then, which is slightly an odd experience. That easy read guide I think is useful for some people, but very limited in many ways to enable people to be able to navigate the whole process. Tom also mentioned I'm a facilitator for a programme which is run by the Law Society called Advocacy and the Vulnerable. Some of you present might have participated in this. It's aimed very much at criminal practitioners, and it's based on very solid research and input from a wide range of very clever and experienced people. And the focus of it is an extended case study in which there are a number of witnesses fought with cognitive challenges or difficulties, and the advocates who participate in that programme have to prepare questioning for those witnesses. I was very pleased to learn within the last few months that the parole board has finally developed a programme run on similar lines for parole board members, and I've just discovered that it's compulsory for members and that around half of the parole board membership have undertaken it, which is a very positive development, which I'm hoping is going to bear fruit for in the way that parole board members deal with parole hearings in the future. So in the limited time I've got, I wanted to say a little bit about how parole proceedings work, particularly with reference to challenges faced by neurodiverse prisoners and their legal representatives. So quite a bit of the stuff that I wanted to talk about is very much echoing what Dr. Tom has said in his presentation. So one of the particular problems it relates to screening. So we will find ourselves acting for people who have already been in custody for a long period of time, and in some cases, it's I will meet a client, and it's screamingly obvious to me that that person has a neurodisability, and it either hasn't been spotted at all, or if it has, it's been ignored. And actually, in more recent years, it's the latter that's more prevalent. So what I would tend to find is that you'll see a report within a parole dossier which would mention that someone might be autistic or has ADHD, and the report writer has not really done a great deal to think about what that might mean for them and what that might mean in terms of working with them. So the majority of parole cases are for prisoners who are serving some kind of indeterminate sentence, and so their parole review will happen right at the end of their minimum term or tariff. And so at that stage, a prisoner is either seeking release or to move to an open prison, and they've usually spent a very long time in prison. One of the things that I have noticed is there's often a lack of comprehensive information sharing. So somebody might have done an extremely good job acting for somebody in their criminal trial, but a lot of the information from there, unless it's made its way to into the judge's sentencing remarks in a meaningful way, that's going to be missing from a parole dossier. And so the only time that might turn up would be if somebody has either provided the prison with that, or their legal representatives have dug it out and asked for it to be added to a parole dossier. And then there will be cases where someone's been convicted and sentenced without expert reports, but they quite clearly have some difficulties which should have been spotted earlier. Then you will find that even if someone has been identified as being neurodivergent, there's a lack of understanding about what difficulties they may face and how they might be addressed. Most prisoners who want to be released on licence will need to have accessed and participated in interventions or programmes. Lots of those are not well adapted for neurodivergent prisoners. There's a lack of availability of one-to-one work, so especially adapted work for somebody to do to demonstrate a reduction in the risk that they might pose. And there's a lack of effective release planning to take into account somebody's neurodisability. I'm going to use the term difficulties as maybe the most neutral term. I'm conscious of the fact, and I know that Emma's going to speak about this, is that it's really important that people don't necessarily identify something as a deficit. It might be a difficulty or a challenge that someone might face, but I think the sort of uniform issue that people who I've acted for would want someone to act on is that they want somebody to recognise the particular difficulty they face and want that to be taken seriously. And that involves analysing in an effective manner what those difficulties really are and how they're manifested. So to give an example, somebody who is autistic may be particularly focused upon rules. Again, I appreciate that not everybody who's autistic is going to experience that, but this is something that happens quite commonly. And somebody who is especially focused upon rules, the way in which that manifests itself may be interpreted by officers or particular officers as pedantic, as awkward. It might lead to conflict. It can lead to adjudications, adverse conduct reports, or security intelligence. And these become amplified in parole reviews and can be interpreted as evidence of risk-related behaviour when that might be entirely unfair. The other thing that's particularly common in parole reviews, as it echoes some of the points that have been made by other speakers, is that people waiting for parole reviews are having to contend with chronic delays. So somebody who's focused on rules and timescales are going to be particularly vexed by the fact that they've been told that a particular process is going to take a certain amount of time, and a hearing will take place by this date, and invariably it doesn't. And that might lead to some significant outbursts and people not doing what they're supposed to do is particularly be responded to particularly badly by someone who's very much focused on somebody following the rules that they're supposed to do. And another issue that people find is that if a case is particularly complex, that they're doubly punished because in terms of delays, but because their difficulties or adaptations required for hearings or the complexity of their hearings may mean that their hearing takes a lot longer than other people's to come around. Another particular problem that people will face is that expert reports that might be needed to guide how their case might be managed are only directed and commissioned once the parole board has got hold of their case. So bear in mind that this is right at the quite often at the end of their sentence, or should be the end of their sentence. That's really too late. And so one of the jobs that of decent advocates is to try and flag that as early as possible, and to try to ensure that if a report is needed, that it's directed and commissioned as soon as possible, so that somebody can avoid the additional delays that they're going to experience otherwise. So one of the most important questions, and this is repeating a theme that I'm sure you've heard quite a bit this evening and in other sessions, is who is this person that I'm working with? And so there may be a diagnosis or a label that can be important or helpful, but it's not always enough. And so perhaps the key thing to identify is what communication difficulties or challenge might this person face, and as a result, what responsibilities do those working with them have as a result of that. And again, drawing on my own experience and experience of my colleagues, somebody might struggle to articulate what they might benefit from. So I think one of the temptations is to say to people, they act for, well, what do you think would be helpful for you? And I realise quite often that is an entirely overwhelming question to ask somebody. And so I've reflected on that, and quite often the most important and useful thing that I think that I can do is to be really attentive. So spending some time speaking to the person I'm acting for, trying to understand and to test out what particular challenges they might have, and to make suggestions to them, and testing out whether or not they're particularly relevant for that person. And then I will try to advocate on their behalf. So to think about what adaptations might be needed for them to have a fair hearing. Are the assumptions which might be made about that person's conduct or their personality, or the risks they might pose, are they fair and accurate, or might they be better explained by the fact that they're neurodivergent, and that something that might look like risky behaviour might not actually be relevant to an assessment of the risk of serious harm they might pose. So I know that's a very sort of speedy overview. I'm going to hand over to Emma. I think she's going to speak a little bit personally about some of her own experience, and hopefully we'll maybe give a little bit more of a sort of concrete example of some of the things that I've tried to highlight here. Thank you. Cheers, Emma.
Thanks, Andrew. I also have no slides, so you have to deal with my face. As mentioned in the intro, I am autistic / have autism. I am personally not fussy about the specific language to describe myself. This is both a blessing and a curse with regards to representing neurodivergent clients as a solicitor who represents them before the parole board. My 5 minutes are going to be focused more around sort of informal, personal reflections about representation in the parole setting. My decision to be open about my autism is a deliberate choice. I have been cautioned about it in the past. There is still a lot of stigma about what it means, and concern about whether people will question my professional competence. I would highlight that some language today inadvertently quite often assumes that the people who are neurodivergent are the people who are the subjects of the criminal justice system, whereas there are actually, in fact, neurodivergent people everywhere. And I get a lot of very negative reaction from some of my clients where possible neurodivergence is raised for them, as they have very negative associations about what that might mean for them. There can also be a tendency amongst parole professionals, in my experience, well-intentioned, of taking a paternalistic or even infantilizing approach to clients who are known to be neurodivergent. Often there's a confusion with learning needs with neurodivergence. And it can be extremely frustrating to be in a parole hearing as an autistic lawyer with an autistic client, where my client is being spoken to as if they're a toddler. The plural of anecdote may or may not be data, but I have a lot of experience before the parole board, and one thing you need to be good at as a parole advocate is observing your client, as Andrew said about being attentive. Whilst the various identified neurodivergent conditions have clusters of similar difficulties, everyone's specific difficulties will be different. And the client in front of you may have significant difficulty in identifying any support needs or adjustments for parole hearings. Poor interoception is common. Mine is terrible. The simple question, how are you, can be very difficult. Andrew often asks me this question during the course of our work week. I don't think I've ever given him a useful answer. There's usually a pregnant pause. It is far too broad a question for me to usefully answer. Specific focus questions work better with regards to adjustments, or if someone needs a break. So asking, is it too bright in here? Is it too warm? Do you need to go to the bathroom? Are you thirsty? In my experience, tends to work better than, are you okay? If someone has a diagnosis or a suspected diagnosis, also don't be surprised if they appear entirely fine without closer scrutiny. It does not mean that they don't have needs with regards to how the hearing is conducted. The best way to illustrate that is to use myself as an example. I assume that right now I appear to be a fairly eloquent and confident speaker who doesn't have any communication or cognition difficulties. But that's because I'm an expert at masking and social mimicry. I am currently consciously remembering to do a lot of things. I'm going to tell you what they are. I am remembering to face the camera so that you can tell I am talking to you and that my voice projects in the correct direction for you to hear me. I am remembering to look at the camera periodically, again, so you know that I'm engaging with you. I am keeping my voice at a volume that can be heard and remembering to talk slowly enough for the human brain to comprehend. This is significantly slower than my natural talking speed. I am making sure to enunciate my words and not mumble. Even my accent is something I need to concentrate on. You would not be able to guess where I am from based on this one. I'm ignoring all of the other noises and visual things around me, and there are a lot of them. The hum of the radiator, the laptop fan, the way my socks are digging into my feet, my screens are too bright, my cat decided to come in 2 minutes ago, and that's really distracting. And of course, I am currently talking at you rather than engaging in a reciprocal conversation. All of that is before we get to listening to the other person, taking in the specific words they are saying, processing them, and formulating an appropriate response. I go through all of that to highlight that there can be a lot going on within the head of a neurodivergent person that isn't apparent and can impact how well they are able to engage with you in an interview or in a parole setting. If you translate that again to someone who is, for example, trying to call me from a wing telephone and the cacophony of noise and things that will be going on there, the issues multiply. So allowing for things like processing time, possible repetition can be very important. Clients will often give evidence in the middle of a parole hearing in the order of witnesses, and it can be important to go back to them later to check if there is anything they wish to add to answers that they've given previously, making sure that they get that processing time, for example. And I think, yes, my 5 minutes is just about up, so I'm going to stop there, but I'm happy to go over any of that or answer any questions.
Wonderful. Thank you, Andrew, and thank you, Emma. As Emma's just mentioned, if there are any questions, then please do put them in the Q&A box. We've got one more talk, which is a talk that I'm just going to give, and I'm going to go through it very briefly. Hopefully I'll just be 5 minutes going through that. And then if there are any questions that anyone wants to ask, we'll have an opportunity for that to be done. So I'm going to hopefully share my screen. What I just wanted to talk about very briefly is something which I'm not seeing particularly, and whether it's been looked at before. But obviously, the relationship between, or the difficulties that neurodivergent people face in the criminal justice system covers a wide variety of aspects. We've already had mention of in the trial process how people come across and difficulties in communicating. But what I was wanting to just have a look at was to look at the relationship between, specifically in this case, autism, because they were the only examples that I found, but how those relate to elements of criminal offences. And so for criminal practitioners, things that they may need to be aware of, because it may have an effect on the actual elements that the prosecution have to prove, or the potential defences available to someone charged with a criminal offence, which may be affected by their neurodivergence. And it's something which I've probably only just really been able to skim the surface of, and I'm keen to look at it further. If there's anyone who's looked at this or is interested in collaborating in some way, then please do get in touch. But I think it's potentially an important area, because what I've done is essentially look at some recent appeal cases, and a number of those have led to convictions being quashed, because the issue of someone's neurodivergence wasn't raised at the trial, and it may have had an impact on the jury's verdict. And so I've looked at a few different offences, because obviously the different offences, it depends on what it is that the prosecution have to prove as to how it may be relevant. But the first one, and I think probably the earliest in time, was a sexual offence, and the question of whether or not the defendant had a reasonable belief in consent. And the finding of the appeal court, after the diagnosis had come to light, sometime after conviction, was that the assessment found that it had impacted on his ability adequately to determine another's intentions or beliefs or desires in ambiguous situations. And that unless an unequivocal statement or set of actions was made by the complainant to ensure that he ceased his unwanted attentions and left the premises, he was compromised by this disorder. So here, on the facts of the case, the complainant's account was potentially capable of being interpreted as being equivocal in relation to consent. And in those circumstances, the fact that the jury weren't aware that this particular defendant's autism impacted on his ability to understand that, then it meant that the conviction wasn't safe. Jacobs was a very recent case on the same issue, and it confirmed that the reasonable belief in consent could include a defendant's specific characteristics, and that's something which strikes me as a point that some defence lawyers may not pick up on, and that the fact that someone's own neurodivergent presentation may be of relevance to this issue. And it confirmed that there may be some cases in which the reasonableness of someone's belief, applied here in relation to a sexual offence, but potentially an issue in other criminal offences, where it depends on the reading by the defendant of subtle social signals, that if their ability to do that is impaired, that may be something that the jury need to take into account. And in that case, they found, although it didn't apply in the particular circumstances of that offence, that there were cases in which it may well be relevant to finding out whether for the jury to determine whether the elements were proved, to know that a defendant had was autistic and had particular difficulty, if it was of relevance, in reading subtle social signals. It's also relevant in sexual assaults, because one of the issues which juries have to consider is whether or not, where the touching is not inherently sexual, whether it was sexual because that was the defendant's purpose or motivation. And the defendant in this case, their particular neurodivergence meant that they had a difficulty in understanding social situations and in reading the thoughts and feelings of others. Obviously, as has been said before, it's going to be different for every person. And it's one of the points that I'll come back to, is the importance of a person-specific assessment in relation to areas where this may arise. But with this particular defendant and with these particular circumstances, it was something which was of relevance. Interestingly, I think it was this case in which the defendant had been convicted of a series of sexual assaults, and it was when he was coming before the parole board. that I think those representing him or someone involved in the system picked up on the fact that he may be autistic. He was, so that was subsequently confirmed. He was released from prison. He was charged with another series of offences carried out previously in the same period. In the second trial, evidence as to his neurodivergence was put before the jury, and he was acquitted. And this appeal related to that new evidence in relation to the original set of proceedings, and the convictions were indeed quashed. Two other a recent case in relation to different sort of criminal allegations, this time relating to terrorism related offences. And in particular, perhaps if I focus on possession of documents, because that is an offence where there is a reasonable excuse defence. And what the Court of Appeal have said is it's not straightforward. Again, as with all of these, it depends on the individual person, and it depends on the individual circumstances as to whether or not it's of any relevance. And it can't make an unreasonable excuse reasonable, but it can be a relevant factor for the jury to consider. The point, perhaps most importantly, from Dunleavy is that the expert report that had been prepared for the trial, certainly I think there was a retrial before it got to before he was convicted, but in relation to the first trial, wasn't defendant focused. It dealt with the possible effects of autism, which wasn't focused on the defendant. And so really the Court of Appeal said, well, that's of absolutely no use to us. There needs to be an assessment relating to this defendant and the facts of this case. And it needs to be set out in advance in that report so that the judge can make an assessment as to whether it's relevant, and if so, how. So it's a really important matter to bear in mind. And then I think just finally to cases in relation to murder trials. Now in BRN, again, very recent case, the subsequent diagnosis of the defendant having autism, the court held in that case it wasn't relevant to the issue of whether there was an intention to kill or cause serious harm, which the prosecution would need to prove. The facts in brief were that it was a stabbing and that the defendant here was the person who was said to have done it. There wasn't room on the facts of the case, it would seem, for any ambiguity or about the intention. But there was a point raised in relation to self-defence, which was the defence that had been advanced, or rather defence of another. And the Court of Appeal said, well, in some circumstances, that may be relevant to whether someone genuinely held a belief that there was a need to use force. For example, if that belief depended on reading a particular situation in a particular way, then it may be relevant for the jury to be made aware of their neurodivergence. But in the facts of this case, it wasn't something which arose. And again, another very recent case. There have been quite a few of them recently, and that's one of the reasons why I'm interested in sort of seeing how the courts have approached it and how they've approached it over time. But Sosongo was murder word. It was a joint enterprise, and the defendant in that particular case wasn't said to have been involved directly, but they were someone who had been said to be acting as a lookout and had travelled to the scene with the others who then carried out the attack, but he was some distance away when it actually took place. So the factual matrix was very different. And what had been prepared for the appeal, again, hadn't come to light until after the trial, was that this particular defendant's autism and ADHD had these very particular effects. in terms of logical decision making, consequential thinking, suggestibility, and social interaction. And on the facts of the particular case, the court held that that may have had an impact on his ability to recollect and process relevant information. So there'd been previous incidents between two alleged gangs, which the prosecution said led up to this. And so that was a point that they relied on when cross-examining the defendant about why he'd gone in the taxi with these other people. And what they found was that, as I've set out some of the other quotes, but in short, that the evidence that was now available in relation to the defendant's ASD and ADHD may have had an impact on the jury's verdict. The conviction was quashed and a retrial was ordered, and I think at the retrial, the defendant was acquitted within about 30 minutes of murder. It's perhaps good to finish there with an example as to just how important it is that these issues are raised and looked at properly, and that people are aware of how it can impact different areas of the trial process, not just the evidential side of it, not just presentation and communication, but also the actual offences themselves are something that needs to be looked at and how it may be relevant in that situation as well. So that's a very quick run through. The slides will be available to everyone after the webinar. But I'll just ask now if we've got, let's see if we've got any questions in the Q&A. I think most of them, our panelists have done a wonderful job of answering as we go through. There's some great information being shared on the Q&A. And so if people want to have a look at that before they log off, I'd recommend that. And just in relation to Jen's question at the end there, yes, the recording will be available on the Garden Court YouTube channel. Could I also just mention, as Emma's referred to, the neurodivergence not just being limited to defendants or witnesses in the criminal trial or the criminal justice system. And I'm going to plug our next webinar, which I think is on the 16th of April, which is in relation to neurodiverse lawyers. And so we'll be hearing from a number of people, lawyers, counsels, solicitors, talking about their experiences of working in the justice system, both in terms of a celebration in celebrating the importance of that diversity amongst those who work in the system, but also being a frank and honest discussion as to some of the hurdles and difficulties that they've faced. So we hope that many of you will join us for that. And thank you very much. And sorry, we've got a little bit over time, but it's been fantastic to hear from everybody. I say we could quite happily carry on. I could certainly happily carry on listening to all of our panelists for the rest of the evening, but I'm afraid we're going to have to draw a line under it at some point. So thank you once again to everyone on the panel. Thank you very much to everyone who's joined us to listen to the talk this evening, and we look forward to hearing from you or to seeing you at further webinars in the future. Thank you very much.